guest with us here as we discuss the power of trusts and protecting your assets and legacy. Real quick on Fort Pitt Capital Group, we are a investment management firm that provides a boutique feel, and we really pride ourselves with a high level of client service, which is kind of what keeps us going today. So with that, I'd like to introduce Bill Engel. Bill, would you like to introduce yourself?
Hi, yeah, appreciate everybody joining us today. I know this is a topic of great interest. There's a lot of questions, anxiety, myths, and misconceptions around trust. So we appreciate our key speaker here joining us and being a resource. Again, Bill Engel. I'm one of the principals and senior wealth advisors here at the firm. Been with Fort Pitt Capital for nearly 11 years, and it's truly a great place to be and work and do what we do. So appreciate everybody joining us.
My name is David Plante. I've been with Fort Pitt Capital for a little under a year. I've been in the industry for 25 years plus, and happy to be joining a firm such as this. Just a little bit on me. I've been in the Harrisburg area since 2014, and so I'm looking forward to sharing this information. And now I'd like to introduce Lance Sherry. Lance is with our sister firm, Kovitz. We're excited because I'm sure many of you have heard about our merger with Kovitz. And as we go through this, it's nice to have resources internally to us, such as legal experts as Lance. Lance, would you like to say a few words about yourself?
Great, David. Thanks everyone for coming today and participating. So I'm Lance Sherry. I am a wealth advisor here at Kovitz, located out of Chicago. My background is as an attorney. So I went to law school here in Chicago and spent my first 3 years in private practice before switching over to financial services about a decade ago. Obviously, with my legal background, my area of expertise is in planning, especially when it comes to long-term planning for you and your family and for estate planning purposes. I'm also a certified financial planner as well, so I have that financial background to go complement the legal background, and I look forward to some of the questions that have been pre-submitted and the discussion we're going to have today.
Excellent. Thank you, Lance. So as we kick this off, just so if you want to ask a question, real briefly, here's how you interact. If you're on a mobile device, you just get to slide over to the bottom there where it says Q&A, and you'll be able to ask your question. So the only people that can see your questions are the presenters, and we have a number of questions that came in, so we'll try to get to as many as we can. If you're on a computer, if you have the little bar on the bottom, same thing, very easy. Click the Q&A button, and again, we can only see the questions that you're asking, so they're not going to be out there to the wide audience. So with that, we'd like to kick it off. We don't have much of a PowerPoint, which is great because we really wanted this to be conversational, and we had a number of questions that were pre-submitted, and I'll kick it off over to Bill, who has a number that he's wanted answered.
Yeah, thanks, David. And Lance, excited to get started with this. But one question I would ask that you address first, or a topic that I'd asked you to address first before you dive more deeply into trust specifically, is the idea of probate. That drives a lot of our discussions and questions from clients and prospective clients. Can you take a moment, explain what probate is, maybe what it isn't, and how trusts affect it, or vice versa?
Sure. So probate is the process of the court administering your estate or your affairs upon your passing. So there are two ways to kind of handle your assets when you pass. Either one is through probate, which most people would like to avoid, and I'll get into that for a moment, or in a moment. The second is through a will and a trust, which is obviously what the majority of our discussion is going to be today. So let's say you you die intestate, you don't have a will, you don't have a trust in place, you go through the probate process. Even if you have a very simple estate, it still means that the court has to sign off on all the various assets that you have for either transfer, liquidation, etc. So it can become a onerous process, maybe not necessarily from a financial perspective, but you're going to have someone who is the executor over your estate, and they're going to have to go through the court to get approval to put your house up for sale, to sell it at a certain, a listing price, to transfer assets to heirs, or other family members, whatever the case might be. So probate's going through that process, where you are having the court approve the proceedings of distributing assets from your estate to however the court determines. And something I was talking to Bill about before we jumped on this call is I always like to try to tell all my clients that you have an estate plan currently. It's just the one that the state that you live in has decided for you. So you are subject to the laws of the state of Pennsylvania, assuming that the majority of the people on this webinar are in Pennsylvania. You're subject to the laws of the state of Pennsylvania. And the court will administer your estate, your assets, pursuant to those laws. They're not going to deviate or dictate from it. They're not going to care if you have a family heirloom that your niece wants, or this watch that you want your son to have, or whatever the case might be, right? They're going to say, this is what the state of the law is, and here's how we're going to administer your state based on, or your estate based on that state law. So most people don't want the state to determine how their assets are going to be transferred. I know certainly in the state of Illinois, we have a very bad reputation from from a state government perspective, that they aren't necessarily the best at determining how assets should be utilized. And so for most clients, even if you have what would be deemed a relatively small estate, most clients want to avoid probate because it could be onerous for the individual who has to administer your estate, and you want to be in control of how your estate is distributed and divided to your heirs. By putting a trust into place, this is the main reason for setting up a trust, you avoid the probate process. So your administrator will go to the court and say, all assets are subject to the terms of this trust document. They review the trust document and say that everything looks good here, and then you can come back and finalize the estate at some point down the road, right? But the going through and having a trust is what helps you avoid probate. One last thing about this, so I don't drone on too long, is probate is a very public process. It's a court proceeding. All of your assets, all of your debt, everything that you have will be subject to public review. That doesn't mean that people go in and review every single thing, but if you have nosy neighbors or business partners or whatever the case might be, the probate process is available for the public to go and review. And so many people want to be private. Many people don't want the onerous task of having to have the estate administered. They will set up their trust to have it divided pursuant to their terms.
So, Lance, real quick, we had a question that came in here. If you already have a will, is that pretty much why you would want to still have a trust?
Yes. So a will and a trust try to do similar things, but not accomplish the same thing. So not surprisingly, the law can be antiquated from time to time. And the way that it works is that we set up what are called, or we tell our clients to set up what are called pour over wills. So during your lifetime, you want to set up a revocable trust that titles of the majority of your assets. And obviously we'll get into a lot more of that during the discussion. The will should act like a catch-all. It should be a safety net for you that says anything that wasn't titled in the name of my trust for whatever reason should be distributed to my trust upon my passing. So a pretty standard type of asset that's not titled in the name of a trust is a car, right? Most people don't go through the process of titling their cars, unless you have like an antique or something along those lines, in the name of their trust. So the will is the catch-all that says any asset that I don't want specifically distributed to a certain individual or person, then will go to my trust, and the trust terms will dictate the distribution of the estate.
So Lance, just to be a little bit clearer, so if I'm in the Great Commonwealth of Pennsylvania and I have an IRA and I have my house and maybe I have a non-qualified account that's of some size, and I have a will. So the IRA has a named beneficiary. The will is a I love you will that says everything goes to my spouse, and if we both go, it goes to my kids. Are my assets going to be going through probate?
Some will. So the way that qualified accounts are set up, or anything that has a beneficiary designation, is that is contract law. So that goes to the individual who that goes to the individual who's contracted, right? The beneficiary, so the beneficiary of that. The house, if it's titled as joint tenants, right, should not be subject to it. But if you have as you described it, Bill, a non-qualified account, or like an investment account, just a brokerage account or investment account, depending on how it's titled, that would be subject to probate. And so, I guess I should have said this up front. We all should have said this up front. Everyone's individual situation is going to be different and unique, right? There's no one rule that fits every single client or household out there. But for the majority of our clients, there's no reason not to have a trust in place, or there's not to have a coordinated will and trust in place, because most people want to avoid that probate process. Even if it's not going to be onerous per se, it's just easier to have one legally binding document that handles all the asset transfers.
Thank you. So I guess that's a natural segue to talking about trusts, and if you don't mind, Lance, taking us from the basics, right? Like, what is a trust? What are the various parts of a trust, and maybe what isn't a trust?
Sure. So a trust is just a legally binding agreement or contract, right? It's between three parties. The three main players are the grantor, the trustee, and the beneficiary. So the grantor is the individual who establishes the trust. The trustee is the person who administers the trust, and the beneficiary is the person who's the beneficiary of the trust. That one's the easiest to understand of the three. For most people, when you set up with something called a revocable trust or a living trust, it might have different terms in different states, right? But what I'll refer to throughout this presentation as a revocable trust, most times you are all three parties, meaning that you are the grantor, the person who sets up the trust, you're the trustee, the person who administers the trust, and you are the beneficiary, so you're the beneficiary of the trust. So when you're alive, the trust can act in any way that you can act, and you can act in any way that the trust can act, because you are all three parties. There's a unity of all three parties in the trust. So the trust is functionally just your alter ego during your lifetime. So then why do you set up a trust, right? Well, there's two reasons. One, either you become incapacitated. So what happens? How do I want my affairs to be handled if I become incapacitated? If I get into a car crash and I'm in a coma, if I suffer, from dementia or from Alzheimer's, any other reason why you might be deemed to be incapacitated, right? So your trust document will say, I give authority to the successor trustee to handle my affairs during my lifetime in XYZ manner. And then upon your passing, that's the other reason why you would want a trust set up. It's saying, okay, now that I'm gone, here's how the assets are distributed. Most times it's to a surviving spouse, and then after that, it's to the children. And whether it remains in trust or is distributed outright, again, that's by an individual case-by-case basis. But at that point in time, the trust becomes irrevocable, right? So during your lifetime, it's revocable as long as you have the ability to be all three parties. Upon your passing, it's irrevocable because one, you're done. Two, someone steps up in the trustee capacity, and 3, you're no longer a beneficiary of a trust when you're not around anymore, right? So during your lifetime, you can revoke, amend, change, take assets out, put assets in, do anything you want with the trust, as long as you have the capacity to do so. Upon your passing, it is then distributed by the terms of the trust agreement. So it is, one, the ability to avoid probate, but 2, it's really, and what it really comes down to is the ability to make sure that your heirs, your family, your charities that are important to you, receive the assets the way that you want them to receive them. So the trust allows you to dictate those terms and have a binding document for people to say, this is what, Bill wanted, this is what David wanted.
So Lance, I appreciate that. And just to be clear for people, and I guess for myself, so while you're alive, if you've established a irrevocable trust, there are no real protections. This is a document in place for when you are either incapacitated or gone. So, because again, I've had people bring up to me, hey, I want to put in a pool. I think I need a trust. And so just to be clear, this is not really going to do or change anything until and unless it becomes irrevocable. Is that a fair way to say it?
That's a great point, and thanks for bringing it up. So because you have full access to everything, that also means you don't get the asset protection that is typically associated with trusts, right? And I'm sure we have some questions about that that we'll discuss later. But during your lifetime, you're not given any sort of special protection of any of your assets just because it's held inside of a revocable trust. Now, if it's in an irrevocable trust, that's different. But in a revocable trust, you don't have any sort of additional protection because, again, if you can invade the corpus of the trust property, then so can other individuals, right? That's kind of what's fair under the rules of law. What we do and what we work with on clients if they're looking to protect their assets while they're alive is property and casualty insurance is the best way to protect those assets while you're alive. Upon your passing, then different sets of rules come into play.
Thanks for that.
Excellent. If I can ask next, really, what kind of personal or familial situation would be the most beneficial, or is most common in establishing a trust? And where does it make sense?
Yeah. So, again, broad strokes, it'll be every family situation is unique, right? And you need to consult with either your attorney or really you should talk to your financial advisor to plug the 3 of us as to why we're here and valuable. So I know as my background as a estate planning attorney that every time a client calls or emails me, I need to charge them for that conversation compared to what I do now, where we are part, you get all of our services as part of our management fee, right? And so what I always try to tell clients is, you can have as many conversations with me as you want to determine this is what I want to do. Here's how I want to look. This is the people I want to get these assets, so on and so forth. And then we go to your attorney after the fact and they get into the specifics of the drafting. But if you can cut out, 90% of the legwork up front, one, not only does it allow you the ability to kind of go in, eyes wide open to your conversation with your attorney, but 2, you save yourself a lot of time and hassle with the attorney for them to kind of figure out what's important or not important. To circle back, David, to answer your question, so it probably makes sense for the majority of the people who are on this webinar and for the majority of our clients to have a will and trust in place. Again, there are certain circumstances where it might not, but every individual has something that's unique to their family dynamic where they would want their children, their spouse, nieces and nephews, again, the charities that are important to them, friends, whomever the case might be, to receive their assets in the most efficient way possible, right? We're talking about, from a distribution standpoint, we're talking about from a from a tax planning standpoint, but also going to, kind of what Bill asked about a moment ago, is this also provides asset protection for those assets, right? So if assets are inside of a irrevocable trust, which all trusts will be upon your passing, and they stay in that trust, third-party creditors cannot go and put invade the principle of the trust if something were to happen. So there's two very common scenarios. One are car crashes, right? That's the most common type of liability out there. It's a car crash. Your child causes a car crash. They cause damage in excess of what the insurance coverage is, and the defendant says, look, there's a trust I can go and invade. Well, if it's in their name individually, as we just talked about a moment ago, those assets could be subject to the lawsuit. If it's in the name of the trust, it's not going to be able to be invaded for trust, or for the lawsuit purposes. So the first is to protect it against third-party creditors. The second is to protect it against divorcing spouses. So most people love their son and or daughter-in-law when they're a member of the family. But when they're not a member of the family, they're less inclined to give half of their wealth away to that individual just because their son or daughter got a divorce, right? So we set up the trust. We tell our clients to set up their trust in such a manner where their heirs have the ability to get the income and principal that they need during their lifetime. The terms are set up as such, but to protect it against outside third parties. So for most individuals, that is probably the scenario that they're most looking for, right? Is to protect your assets for the long run for the benefit of your family.
Excellent. What are some of the common misconceptions and common mistakes people make? Whether they, one, I guess, common misconception of having a trust and what it may or may not do. And then we can follow that up with some of the common mistakes people make when they do have a trust.
Sure. So the first one, as we already hit on, as Bill pointed out earlier, is that the trust does not provide any additional layer of protection to your assets, assuming it's a revocable trust, right? We talk about an irrevocable trust that does add an extra layer of protection. But just because you put a asset in trust, that in and of itself doesn't add any additional layers of protection. The second thing is just because you have a trust. So let's say you talk to us, you go through the process, you say, yep, I want a trust. This makes sense for me and my family, everything along those lines. We work with an attorney, we get a trust set up in place. That's great. Just because you have a trust that's executed doesn't mean that the trust actually owns anything. So you have to go through the process of retitling your assets to be owned by the trust. That sounds like a very difficult or onerous process. For us on our end, it's just paperwork. It's truly not that difficult of a process. But a lot of people who don't work with a financial advisor, who are just waiting for their attorney to do the retitling on their behalf, they're willing to do it. But again, they will charge you a fee to do the retitling for you, right? And they're probably not going to call your bank and make sure that your bank account is retitled. They're not going to call your financial advisor and make sure that we get everything retitled into the name of the trust, right? So just because without retitling, without going through the process of retitling your assets, you just have a very expensive piece of paper that won't be actually effective until you pass, right? Upon your passing, everything will flow through the trust still. And, at that point in time, all the assets will be distributed through it, right? But until that point in time, nothing is if it's not titled in there, you're missing out on the whole point of establishing the trust.
Excellent. Excellent. And, really, what are some of the downsides of owning a trust?
So I wouldn't say there's any downside for owning a trust during your lifetime, right? Because again, you can invade every sort of, the only downside I can think of is if you don't want to pay the attorney's fees to establish a trust. You do need to work with a legally or an attorney. What I always tell my clients is I am an attorney. I am not your attorney, meaning that we have to get a attorney involved to draft the document. the process of going through probate will be more expensive than the process of getting, in most situations, than getting the trust established during your lifetime, and working, with your advisors to make sure everything is retitled and going to be handled properly upon your passing. But other than that, there's really no real downside during your lifetime to having a trust set up and assets retitled into it. Because again, at any point in time, you can, what I would non-legally describe as blow up the trust. So you can invade the trust principle. You can take all the assets out. You can distribute all income to you. You can do whatever you want with those assets until you're incapacitated or upon your passing, right? So during your lifetime, there's no real downside. Upon your passing, one of the, as I talked about a moment ago, the benefit of having assets in an irrevocable trust is that you get asset protection and estate tax protection, right? That should have been the other thing I mentioned earlier. So currently, the federal estate tax laws are such that every individual has functionally $14 million that is protected from federal estate tax. In the state of Illinois, our taxpayers have the pleasure of also paying state estate taxes. In Pennsylvania, my understanding is there is an inheritance tax, not an estate tax, which is similar but not the same. But for our purposes, let's just assume that we're talking about the federal estate tax exemption, $14 million for couples. It is $28 million combined. Okay. For individuals, most of us on this call are not close to reaching the top end of the federal estate tax exemption. If you are, please give me a call. I would love to talk with you more and work with you on how we can work through some of those potential estate tax issues. But for most of us, an estate tax at this point in time is not a major concern of ours. Having said that, the estate tax is subject to tax law. Laws are subject to political parties and changes. I'm not sure if anyone heard or not, but we had a pretty big election recently, back in November 24th. It's true. We did have one. And the Republican Party is now in control of the White House, the House of Representatives, and the Senate, right? So they control all three parties, or all three branches, excuse me. And without making this any sort of political statement in any way, shape, or form, the odds are that the current tax laws are going to either get extended or some version of what we have in place will be pushed out for the foreseeable future. So it is our opinion that the estate tax exemption, where we see it at today, will probably be pushed out for another 7 to 8 years into the future. But it's always subject to change. It's always subject to revision. We were talking about this before we joined on the call. When Bill started in the industry, the federal estate tax was what did you say, 1.5?
Something like that, between 1.5 million, which obviously caught a lot more people and got a lot more people's attention than 14 or 28. Right.
When I started about a decade ago, it was 4 million. Now we're at 14. We've 3x, more than 3x what the federal exemption is. If Democrats take control, they run on a platform of not wanting to give tax breaks to the wealthy. And so the state tax could be repealed. It could, the law could just not be extended. And if it's not extended at the end of this year, it reverts back to pre-Tax Cuts and Jobs Act laws. And the estate tax would go down to somewhere around $7 million, between 7 and 8, depending on, how inflation shakes out. So functionally, it's getting cut in half from where we see it at today. So you put assets into a trust to protect it from creditors. You also put it in a trust to protect it from estate taxes, right? And the estate tax is 40% above the exemption amount. So if you have an estate of, let's say $10 million today, you would not be subject to the estate tax. If Tax Cuts and Jobs Act rolls back and we go to a $7 million federal exemption amount, you'd be subject to taxes on 40% of $3 million. So working with an advisor kind of helps you figure out how you may or may not be impacted, where you're projecting your wealth to grow long term, and why you might want to put assets in trust. That was a little rambly, but Dave, to then get to the flip of why might that, where's the downside? Any asset that's in an irrevocable trust is subject to the trust income tax brackets. So for an individual at the federal level, the highest rate, 37%, you're not subject to it as a married filing jointly couple until you reach about $750,000 of combined income for the year. So 37% above about $750,000. At the trust level, you are subject to that 37% when you get to $15,000 of income taxes. So it's always a push and pull between, one, do I protect my assets for the long term, and do I protect them from the federal estate taxes, versus, okay, if I do that, what's the income that's going to be generated from this? Would it be better for the income to be pushed out to the individual beneficiaries who might not be subject to the 37% tax bracket, right? That's something that, we as advisors have many conversations with our clients about all the time. And also, it's not necessarily something that needs to be set in stone. One thing that could be in place today, as long as you put the proper terms into place into your, your trust document, could be, change at some point in the future. You could distribute the assets out. There's a lot of different ways to work through kind of the mechanics of it, because laws are always going to be changing. Your family dynamics are always going to be changing. We know what the tax rates are today. I honestly can't tell you what the tax rates are going to be in 2026. I think I have a good idea of what they're going to be, but I can't sit here with a crystal ball today saying I know exactly what it's going to be, right? In an ever-changing world, you need to figure out what makes the most sense for you and your family.
Sure. And last question for me for a bit. Which assets, because you mentioned assets a number of times, which assets probably shouldn't be included in the trust, if any?
Yeah, so you don't want typically a car is not entitled, not included in your trust. Your operating cash account at your bank doesn't, it can be, but most of our clients don't. They just have it titled in their individual name or with a spouse. Anything that wouldn't make any sort of significant or material impact on your taxable estate, or would just be too much of a burden from a day-to-day use, right? Like moving money in and out of your your checking account. We typically don't see those subject or excuse me, not subject, titled in the name of the trust. Otherwise, most major assets should be titled in the name of the trust. One special caveat or carve out there are retirement accounts. So retirement accounts, like I said earlier, are a contract between you and the custodian of the account to then distribute assets to your beneficiaries as you've designated in your beneficiary designation form. And so that's not something that's going to be titled into the name of your trust. That's always going to be titled in your individual name, because they are individual retirement accounts. That's what IRA stands for, individual. So retirement accounts cannot be held jointly. Retirement accounts are not going to be held in the name of a trust. Having said that, in certain situations and circumstances, it might make sense for the trust to be the beneficiary of your retirement account. So the trust would not own the assets during your lifetime, but it might be, instead of going outright to your children, it would go into a trust for their benefit. And again, there are pros and cons to that approach. And there's a lot more nuance around it now than there was even 5 years ago, before Secure Act, which is a relatively new tax law that was implemented, came into play. Prior to Secure Act, we almost never saw revocable trust being the beneficiary of the IRA or the various qualified accounts. With Secure Act, they eliminated something called the stretch IRA provision. And because of that elimination, it at least now makes more sense than it did historically to potentially have the trust be the beneficiary of an IRA. That doesn't mean it should. Doesn't mean it should in every situation, but at least it makes more sense today than it did even 5 years ago.
Lance, can I switch gears a little bit? We've talked about the parts of a trust. Can you describe a little bit the process that someone should think through in selecting a trustee? And what maybe the responsibilities of a trustee is, because I've had experience with people naming somebody an executor, and I always say that's like one of the worst things that you can do to somebody. A little tongue in cheek, but maybe not. But the factors that might go into choosing an individual or a corporate trustee.
Sure. Yeah, so I couldn't agree with you more. Everyone wants to be trustee until they are trustee, and then they realize what they have to do to actually uphold their fiduciary standards. So a trustee is a fiduciary of the trust, and that is a different level of standard that's placed upon that individual to make sure that the trust is administered correctly. So they're not allowed to go outside of what the trust terms, permit or dictate, to say, to do something that, well, son one wants this item and daughter one wants, has a sentimental value regarding, whatever the case might be. The trustee has to administer the trust based off of how the trust is laid out, and they're not allowed to dictate or excuse me, to deviate from that. So how do you go about picking a trustee? Well, one, you're the trustee of your own trust upon, your establishment of it. Two, most of the time we see a surviving spouse being named as the trustee or successor trustee to your trust document, which makes sense because you're going to set up the trust, the trust upon your passing for the benefit of your spouse more times than not. And so you want them to also be able to administer the trust based off of those terms, gain access to income and principal, so on and so forth. After that, it's really, there's a very legal or a lawyer answer of me. It depends. What we see in a lot of situations is it's based off of the family dynamics, right? Everyone says that their family gets along until someone's not around for them to no longer get along, right? And so if you truly have a situation where all your children get along and there's not going to be any sort of issues there, then you can name, one child or two children to be trustee or co-trustee of the trust for their benefit, right? In family dynamics where people don't necessarily get along, especially when there might be a lot of money at play, especially when you're not around to control the situation anymore, it might make sense to bifurcate the trustee powers between a family member and a corporate trustee. So a corporate trustee would just be a individual, so like a trust company, a bank, something along those lines where they come in and they handle the, for lack of a better term, the administration of the trust, the paperwork, the legal requirements, everything. In Illinois, you have to give the beneficiaries a notice or an update of the value on an annual basis, right? And so most lay people don't do that, and most lay people are violating their fiduciary duties. Now, there's no real truly bad outcome there because the individuals you're probably giving the value update to are your siblings, and they're not going to, more likely than not, sue you for not doing your fiduciary responsibilities. But many people like to outsource that to someone to be able to handle all the changes, laws required. That law went into effect here in the state, I believe it was 3, maybe 4 years ago. Before that was not a requirement. And if you're not staying on top of the laws, right, then you're going to be subject to laws that you're not aware of. So the potential bifurcation between a corporate trustee and an individual trustee, I like that in certain circumstances or situations because it allows the family members to control the emotional side of the assets, right? And allows the trust department to control the administrative side of the assets, and ultimately making sure that you're in compliance with what you are required to be in compliance on.
Something that you've referenced a few times here, but if you could just specifically address it, and that is, does a trust need to be created in the state or county that you live in? And if you move to another state, do you have to make a new trust or amend that trust?
Yeah, that's a great question. So trust law is subject to your individual state. So every state has its own set of rules. Now, the majority of states are what are called separate property states, and they have very similar rules. They're not identical, but they're very similar. There's a handful, I believe it's 8 states that are something called community property states. So that, like, the biggest one that people would be aware of are either Texas or California, and that's a completely separate type of laws that apply to community property versus separate property. It does not need to be in the county that you live in. It does need to be in the state that you are residing in. And if you then leave that state, so majority of people when they retire, or most retirees move to 1 of 2 states, it's either Florida or Arizona. You would want to update your trust document to be reflective of being subject to the state that you live in. The main reason why is, well, there's 2 main reasons. One, your assets are now subject to a completely different state laws. So you want to make sure that your, wills comply with those laws. 2 is, I'll use a client example I have here in Chicago. They sold their primary home. They and they moved to Arizona, and they're kind of for the foreseeable future, they're kind of living a nomadic lifestyle. So they make a base in Arizona, but they spend time overseas, they visit friends in other states, so on and so forth. And I told them that they should establish Arizona estate planning documents. And they said, well, we already have Illinois estate planning documents. Why would we want to establish it to Arizona? My response was, in Illinois, the only thing that ties you back to this state is your estate planning documents. You have no other ties left or remaining in the state of Illinois. And the state of Illinois can be litigious, especially for people who they believe owe them taxes from a state tax perspective and move to a different state to avoid those state taxes. And so if you get a new legal document drafted that says, I am a resident of the state of Arizona, and you spend more than half the year in the state of Arizona, and you have no property in the state of Illinois, it's going to be very, very difficult for them to want to come after your assets. And these individuals are worth, somewhere in the $10 to $15 million range. And although they're not subject to the federal estate tax, like I said, in the state of Illinois, it's a $4 million exemption. And so the way I tried to frame it up to them, and which I think ultimately got them to move forward with their decision was, if I told you for $10,000, if you made an investment with me for $10,000 and the return I could get you is a $1 million return, you would make that investment every single time. There's no reason why you would not make that investment. You would give me the $10,000, you would take the $1 million in return, right? I'm like, that's functionally what I'm saying here with your estate planning documents. Let's say it costs them, because they have, a little bit more of a complicated estate than the average individual does. Let's say at the most it costs you $10,000 to get new documents that say you are residents of the state of Arizona. Like, you've eliminated the ability for the state of Illinois to come after your assets. And therefore you've eliminated the ability to be taxed on the state of Illinois 16% over 8 million. So for them, say they're at 12.5, that's 16% on $4.5 million. I'm like, the $10,000 eliminates, $500,000 of Illinois state taxes. So it is worth the investment to get that redone. So that was a long-winded answer, but it ties you to the state that you're in. So if you move to Florida, but you have Pennsylvania property and you have a Pennsylvania estate planning document, and you don't give up your homeowner's exemption, and you still have a tie to the community, you're likely still going to be subject to the inheritance tax in the state of Pennsylvania, because you didn't really go through the proper mechanics to eliminate that. If you move to Florida, you go through all the proper mechanics, you establish new estate planning documents. It's much, much, much harder for the state to come back and say, you owe us taxes on the back end.
And so along those lines, it's really about where your official residency is. If I have a $200,000 house in PA and I'm here, 9 months out of the year, I got a $1.5 million house in Florida, doesn't matter. My estate's going to be taxed in Pennsylvania.
Correct, because that's where you have established residency. So where you're a resident is where your estate planning documents should be set up. With that scenario in mind, though, Bill, you should title the name of the Florida property into the Pennsylvania trust. So we see that happen a lot, especially here in Illinois. We have clients who have homes in either Wisconsin or Michigan. And we want those assets to be titled into the name of their Illinois trust, even if the property is located in a different state, because then you could potentially be subject to multi-state probate. So it's the probate process, except your administrator has to deal with it in 2 different states instead of in 1, right? So ultimately, I never tell a client that they should move to a different state for tax planning purposes. You should live in the state that you want to live in for communal purposes, familial purposes, all those reasons why you would want to live in a particular state. But if you're going to move, then you should do it properly, and you should go through the mechanics of, reestablishing all the foundational documents you need to say, I'm now a resident of this particular state.
Thanks for that. And again, changing gears a little bit, we've talked a lot about reasons that you might establish a trust to avoid taxes or probate. Another reason that gets brought up to us as advisors a lot is to protect my assets from Medicaid. So can you talk a little bit about asset protection trusts, what they are, how they work, who they protect, how they protect, and maybe importantly, when do I have enough assets that I don't need to worry about it? When do I have too few assets to worry about it? I'll let you dive in.
Yeah. So again, it depends, right? That my broad strokes answer to everything, and like I said earlier, is everything is subject to your personal situation and scenario, right? At a high level, asset protection trusts are established to do exactly that, protect your assets, right? But with that in mind, that means you're probably giving up some sort of control over those assets, right? Again, going back to who are the 3 parties of your normal revocable trust, or your normal, or any trust. It doesn't have to be just a revocable trust. There's 3 parties: grantor, trustee, beneficiary. If you're all 3, then you have access to those assets and you don't get any special protection like we talked about earlier. If you break up one of those 3, then you move it outside of your estate, and it also becomes an irrevocable trust at that point in time. Now, the way that you can set it up or have it set up, there's something called, and this is getting now, a little bit more into the weeds, right? Something called a spousal lifetime access trust, which is a type of, asset protection trust that then gives the assets to your spouse. So while you're still alive, you have indirect access to all the assets through your spouse, because they are likely the trustee and the beneficiary of that particular trust. But you're moving it to something that's irrevocable, so you're protecting it from creditors, third parties, etc. Doesn't have to be just for a spouse. You can set it up for children. Those are typically called family trust or dynasty trust. They have different names. They serve the same purpose. But the main idea behind it is you're moving it because you want to protect your assets for some particular reason. When does it make sense to do that? It really depends, again, on your facts and circumstances, right? I don't want to give like a dollar amount, because you could be someone who's in a high liability field, right? So if you're maybe like a physician, right, or someone along those lines, something that is subject to litigation more often than the normal type of profession would be. You might not need a lot of money where it might make sense to move assets into a asset protection trust. You could be, we have some, former, publicly traded CEOs from publicly traded companies that we work with, and they have a lot of wealth, but they don't have a lot of liability. They don't have a lot of, complications in their life. It's pretty much how much money are we going to give to charity each year is the main discussion that we have with them. And so even though they might have, 3, 4, 5x of the wealth that, the physician might have, their situation might not dictate that they should have a asset protection trust, where the physician, it might, even if it's at a much lower rate. So I would say, that is on a all this is on a case by case basis. That in particular is on a case by case basis to, have that conversation with your advisor. Don't, bring it up to your, attorney, right? One of Warren Buffett's famous quotes is, "You don't ask a barber if you need a haircut." Right? You don't ask an estate planning attorney if you need more estate planning documents, right? Work with your advisor, work through the mechanics of it, say, here are the pros, here are the cons, here's what this means. But remember, you're moving the assets out of your estate and you won't have access to them. Can you, the number one thing that I work on with all my clients is, will you have enough money for your retirement to survive a, 30+ year retirement, right? Anything on top of that is gravy. But we don't want to give away so many assets for protection purposes that we're, potentially ruining the ability to be able to have a safe and secure retirement.
So, excuse me, as we kind of wrap this up and get closer to the end, what are the general costs associated with establishing a trust? That's a question we've gotten quite a bit in both before we started today and also in our chat box.
Yeah. So, it runs the gamut of how complex your trust needs to be, right? And the more assets you have, or the more complex your family dynamic is, the more expensive it's going to be. I would say, I can only speak of what happens here in Chicagoland. A pretty foundational estate planning documents, which would be will, trust, power of attorneys, is going to run between $3,500 to $5,000. In the general ballpark, right? The more complex it goes, the more expensive it gets. There are some attorneys I work with where their foundational documents start at $10,000. That's their entry price. But that means that you have more than $10,000 worth of needs for, I don't give my clients who are $500,000 to $1 million those attorney referrals, right? You find the ones that fit your clients needs. The only thing I ever tell a client is, you just want to work with a qualified estate planning attorney. You don't want to work with someone who's a general practitioner or who's like, oh, well, we can do that for you, but we primarily, focus on construction law or, contract law or whatever the case might be. You want your attorney to be a qualified estate planning attorney. I would have recommendations for my clients. I know you guys would have recommendations for your clients that you work with attorneys in the past, but I tell them, like, who are people in your neighborhood or at your work, at your country club? What recommendations are you getting from them? Because ultimately all of them are going to be qualified. You want to work someone that you're comfortable with. I had a client who has since passed. And at the time he was deciding between two different attorneys. He's like, they're both great. How do I choose? And I said, well, close your eyes. You're dead. Your wife has to call one of them. Which one is she calling? And he said, attorney A. I'm like, great, that's your attorney moving forward. Similar costs, both highly qualified, but it has to be a personal, that fit as well. And so you can probably find someone cheaper to always do the work. That doesn't necessarily mean that that is the best result for you and your family, right? So this is not an area where you want to necessarily skimp out on an extra $1,000 or $2,000. You don't need to go up to the $10,000 range for most people, right? But you also don't want to be like, well, someone can do this for me for $1,000. So I think I'm just gonna go with them. You're probably not getting the best representation that you can get. And I'll use this kind of as the wrap up. What I tell clients is you should review your trust documents either every 5 years or major life event. Most people probably don't do that. Most people are probably doing this one time, maybe twice during their life until they get to a point where they have such a significant amount of wealth that they need to review it on a consistent basis. If this is going to be a one-time expense, you don't want to go on the cheap end because it'll cost you in the long run, right? You want to make sure that the attorney you're working with is qualified. It's going to have your best interest in mind, and is going to make sure that everything is done by the books and has enough flexibility in there for an ever-changing future.
Excellent. Bill, as we wrap this up, is there anything you'd like to leave the audience with or any final questions from you?
Not really, Lance. We really appreciate your expertise and making this kind of mysterious discussion a little clearer. So thank you again. Thanks for everybody that joined.
I appreciate the opportunity to be on and discuss more with everyone. And you know, as always, please feel free to reach out to any of the three of us. We're more than happy to direct the questions to the appropriate parties to make sure that your questions are being answered. And if you had a question in the Q&A that did not get specifically answered, and you are looking for an answer, please feel free to reach out and we'll be able to provide you with that answer you're looking for.
Yeah, I was just going to say we are keeping, any questions that you had asked that weren't answered previously, either before this webinar or during. I've got it all taken here. We'll make sure that somebody reaches out to try to get you an answer. Whether it's your financial advisor that you're currently working with, or someone on this panel, or somebody that is more qualified if we can't answer it. So with that, we try to do these every 6 to 8 weeks. So our next webinar is coming up on April 22nd, Mastering the Market Volatility and Understanding the Impacts of the Tariffs that we've seen so much in the news. And with that, thank you so much, everyone, for joining here, on behalf of Bill, myself, and Lance. It's been a pleasure, and we hope to see you again soon.